Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Today we are joined in the studio by Dr. Samuel Andrews. Dr. Andrews, SJD, is a United States Ambassador's Distinguished Scholar. He is a professor of intellectual property law at the University of Gondor School of Law, Ethiopia. He is currently a faculty member at the College of Law, Prince Mohammed bin Fahd University. He is also an adjunct professor in legal environment of business, criminal justice, and cybercriminology at Albany State University in Albany, Georgia, USA. He has lectured in the Doctor of Juridical Science SJD Colloquium, Seminar, and Workshop Program of Suffolk University Law School in Boston, Massachusetts. He holds a Doctor of Juridical Science degree from Suffolk University Law School. He also holds an LLM in Intellectual Property Law and Policy from the University of Washington, Seattle. He also has an LLM in International Law and Jurisprudence Legal Theory and an LLB, all from the University of Uyo, Nigeria. He holds a Barrister at Law diploma from the Nigerian Law School, Lagos. He's also a licensed lawyer and a licensed capital market solicitor, a member of the International Association of Advancement of Teaching and Research in Intellectual Property, a member of the Copyright Society of the USA, and various reputable professional bodies. He sits on the editorial board of various law journals and reviews. Wow. I'm honored to be in your company, Dr. Andrews. Welcome to Image Rights by N. Mashinini. Are you well?
Thank you. Thank you. Thank you for your invitation. Nomalanga.
Yes.
I got that. It's a pleasure to be here.
Ooh, load shedding. This second season of the show is focused on African jurisprudence and legal frameworks centered around the protection of image rights. And I have done interviews with experts from Kenya, as well as Nigeria and Uganda so far. And I thought it would be a good idea to bring in the perspective of Ethiopian law on the protection of image rights. And so I would like to start off by asking you, Dr. Andrews, to give us a brief description of the regulatory framework that protects image rights, whether directly or indirectly in Ethiopian law.
All right. So when I got your email, I had to, because I having lived in Ethiopia and studied Ethiopian IP law, I knew that image right, even IP right, is just bubbling up now. If you check the laws, the copyright and neighboring rights protection proclamations, that's the law, the primary laws that governs IP in Ethiopia, it's just recent. It's 2004, and because of the digital copyright issues, the latest amendment was done in 2014 and 2020. There's a Marrakesh Treaty has been made into part of the law. So we have 2004, 2014, and 2020. There isn't a lot of activity on that front of image right, but there are laws, and in Ethiopia we have a unique system that the copyright law, the primary copyright laws that I just mentioned, the copyright and neighboring rights protection proclamation number 410 of 2004 has dealt with the issue of image right indirectly by addressing the issue of photographs and photographic works. So Article 2 of the law has defined that photographs are basically protected, unlike in the US and most of the common law countries, countries and most of Africa, even South Africa, who is the author of a photograph, is kind of convoluted, let me put it that way, under the Ethiopian law, because it says, in the case of a photograph, the person responsible as the author, the person responsible for its composition, and some of the laws is straightforward,
Yeah.
The copyright owner of a photograph is the person who takes the photograph. I think I'm correct. Most of the laws, that like US and most of Nigeria, most of is the person who took the photograph owns the copyright. Yeah. But here we have a law that says the person responsible for its composition. So there's no case law yet so far in Ethiopia that has defined what they mean by responsible for its composition. So you see, that's on one side. Now, outside the copyright law, under the Constitution of Ethiopia, there's what we call the civil codes. That is where the issue of image right is actually resided. That's where it resides. Because, Ethiopia, I would say Ethiopia practices is in a class of civil law traditions. It's not a common law tradition in the country, it's a civil law. So we have the civil codes. And Article 27 and 28 of the civil codes actually deals specifically with the issues of image rights. And 27 is a primary law that defines what is, image right, and what are the boundaries of image right. But this is the problem. I'm going to read a little bit. It says, the photograph of or image of a person may not be exhibited in public, nor reproduced, nor offered for sale without the consent of such person. So, taken from the definition in the copyright laws of who is the author, who is the owner of a photograph, let's assume that the person responsible for its composition also means the taker, the person who took the photograph. Let's
yes.
Let's use that definition. Scholars might differ, but let's put it there. Now, so when your image is taken, you have the right to protect your image from being used. But the sad part about it, I say sad, Article 27 of that civil code almost took away all that right. So Article 27 of the civil code, see, it's very straightforward. The 27 is very straightforward. The photograph or the image of a person, that's 27, may not be exhibited. It looks like copyright laws now. Yes. May not be exhibited in a public place, nor reproduced, nor offered for sale without consent of such person. See, that's the same kind of right copyright gives, you see? That's a similarity. The right reproduction, distribution, make public, and all that, you see. Now, it's replicated here. But you see, this law came before, the civil code came before this copyright law. So the civil code is actually older than the copyright law.
Okay.
So, but this is the problem I have with that law. Now, they gave us in one hand, and now it appears they take it back. Article 28 says, Article 28 of the code, civil code says, the consent of the person, that's the owner of the image now, consent shall not be required where the reproduction of his image or her image is justified, where the consent, where the reproduction is justified of his image by the notoriety of such person, that celebrity, if you have notoriety, or by public, or if you hold a public office, which, or by requirement of justice or police or scientific, cultural, or didactic interest, where the reproduction of the image is made in connection with facts, events, or ceremonies of public interest, or which has been taken, which have taken place in public. Boy, that's a whole lot of fair use kind of,
Yes.
or fair dealing.
Yes, indeed. It sounds like
So,
freedom of expression as well.
yes. So I went to dig to see if I'll have any case study, if there's any case. Sadly, I couldn't find any active case, but a lot of literatures, scholars have opined on defining, because you see, it's, I would say, before we go deep down, I would just say straight from the bar that it doesn't seem to be an adequate protection of the image of a person in Ethiopia, because the exemption or the exclusion clauses are so wide. We have to define the notoriety. Okay, who is notorious under this law? Okay, is it a standard Hollywood, or entertainment, or notoriety, or is it the local lady in the village who is a good musician, who is popular amongst, some traditional, Ethiopia is basically like most of the countries of the South. We are very traditional. And our artistic contents are very, very traditional. You go to the countryside and you see a lot of people listening to, one person there. Within that context of the community, it could be notorious, okay? So we know what it means in common law countries and in some jurisdiction, because there's been a lot of decisions defining who is a celebrity or who's notorious, okay? Now, the other issue is that you can use it. The police can use it if it's for police purposes. Then the things like cultural, scientific, and didactic interests. So that is in a nutshell. Let me leave it there, because maybe we'll come back to this. That's a nutshell what the regime, the jurisprudence of image rights. We have it in the books, but it seems to be that there's, when we look at it, there's a lot of conflicts and a lot of unpeeling to do as scholars of Ethiopia law.
The first observation that I'm making is that compared to the other African jurisdictions, including South Africa, due to our common law history, the first difference with Ethiopia is that image rights are codified, whereas here they're dealt with through common law rights. So that's the first interesting point. But I wonder now, with this definition, with the whole situation on social media, because on social media, people, they post their photographs online, and then others take their photographs and turn them into memes. Sometimes they use them in deep fake technology using artificial intelligence. And I wonder, with all these exceptions that look like somewhat fair use, somewhat freedom of expression, wouldn't memes, in particular on social media, be captured by those exceptions? And thus, it gives me an impression that it's possible for someone to use another person's image in a meme and get away with it in this context, depending on how the meme depicts a particular person. So I wanted to ask, how do these current rules then provide protection for violations of image rights on social media, especially in light of the way in which artificial intelligence is also operating on social media? It's used, for instance, to take down malicious or harmful content, or content that abuses people's rights. So how do we apply this law in the social media context? Because another interesting point, which you've already touched on, is the question of what is notoriety? Because in social media now, we've got influencers who are really on a strange platform, in the sense that sometimes they look like celebrities, typical traditional celebrities, but at times influencers are also just ordinary people, or they start out as ordinary, typical people who don't have that level of notoriety, but then they transition. So how do we deal with that under Ethiopian law, social media and all of that?
Yeah. So yes, I tried to address that issue because I had noticed something about Ethiopian law. There is a paper I gave a presentation. See, Ethiopian law, like most of Ethiopian copyright law, in fact, since we are in the terrain of mostly copyright right now, but it's keyed on economic rights. That it's so heavy, it's so tilted. There's the ideological or jurisprudential background when we're taught about why IP and the objectives and all that, and emphasis initially at the beginning of the scholarship of IP, emphasis was always on information, why the state gives you that monopoly is to reward your efforts so that you could be incentivized, to create more work and all that stuff. But as the productive economy changes into the digital scale, I see the copyright laws itself from the WCT, the World Intellectual Property Law, the World Intellectual Property Organization Copyright Treaty, changing the jurisprudence of copyright to recognize technology as a form as part of copyright protection, and also copyright creativity. Most of the laws now, including Ethiopia, is very heavy on economic rights. It's Article 7 of the 2004. The emphasis is so heavy that if you infringe the principle, apart from these other reasons, to reward creativity and pass on information and knowledge to society, they really look at how you should not undercut creators, So I would think, based on that outline, based on that the ideology, if I would say so, or philosophy, and the jurisprudence, so it will be easy, even though it's this notoriety of such person is not been defined, and it's confusing the way it's put here. I would think that the scale, it will be based on, if you are using it on for instance, Instagram, if you are using someone's image, photograph, for instance, and using it for whatever reasons you want to claim, maybe saying that the person is an Ethiopian popular musician or film actor. Now, what is going to be your excuse for using it? Your excuse is that he's popular, so you can use it. It's a notorious person. But what about the clicks, the money you're going to get from it, especially if you're making money from it? Okay? So if you are trading, you're going to be trading. So you see, image right, we've been talking in scholarship, publicity right, and privacy right, is not key on IP. It's not really key on IP. So the issue of, we are not going to look too much into the factor of the commerce. But in image right, under Ethiopia, you can see that economics is also a major factor. Tilts to reward. So if you're going to use it, If it's parody, if it's satire, if it's you're gonna make fun of it, maybe in a short, let's put it under the copyright exceptions. If you're gonna, but if it's gonna be that you're using it in a bad light, moral rights too. Don't forget Ethiopia also is heavy on moral rights, and it's here in the laws. I would say that unlike in the United States, where you can use issues like moral rights, if you're using it, you are not you've not attributed to the owner, like the code says here, or to the person. The code is not even talking. See, the code is not even addressing the issue of the owner. It's talking about the image, the image itself. Okay, so you might have two issues you're going to be dealing with. You might be dealing with copyright issues of the author, and you're also going to be dealing with the issue of the image right. So you got to be careful how you are using it. And knowing what goes on in the click kingdom, it's money, it's monetized. You have a lot of followership and all that. And the star or the person you are using in the image now realize that maybe you have 1 million followers on Instagram.
Yeah.
That could translate to a lot of money. So you got to share the money with the owner, or it could apply to the people to pull it down. Mm-hmm. So I think that there are enough legal engineering for IP lawyers in Ethiopia to focus on it. Probably at the end of this talk, we might do a paper on it and see how it goes.
Indeed. You know, as you've been describing this, I've been wondering, how do people, or does it happen that in the disputes coming to court, are people claiming on the basis of the privacy right when actually it's an image rights concern? Because I know in most jurisdictions, there's always this conflation of privacy and image rights. In fact, even in many states in the US, there's still a lingering confusion about, are these two rights really separate, or is it really one and the same thing? And so in some states, they'll have specific legislation or codes dealing with what is called the right to publicity, which is image rights in the US. And even in South Africa, for instance, we have this issue, a debate about whether the unlawful use of a person's photograph is actually a violation of privacy or a violation of image rights. And I've been really looking at how in a number of jurisdictions, the states in the US included, as well as South Africa, there's a constant conflation of privacy rights as well as image rights. And I wondered, is it possible that while there are no cases on Article 27, and while there are no cases on the image rights aspects as a whole in Ethiopian law, is it possible that people are bringing in privacy claims when in actual fact the nature of the dispute, really its essence, is an image rights claim?
Okay, I'm going to a little bit because I've seen the literature, and just like I've disagreed with a lot of scholars on the attempt to divide with a very hard line privacy rights and publicity rights. So I'm going to use the US. So the history of publicity right, if you far back, it was the issue of privacy, right of privacy, So it was all about privacy, protect your lifestyle and all that, your home from invasion, what you do. But with the commerce and development, we extended that aspect, the economic aspect, because on the case law in America, for instance, Martin Luther Jr., Martin Luther Center for Social changes and the American heritage products, you see that right of publicity came out of privacy rights, but the monetization, let me put it that way, the commercialization of our images got it to where we now refer to it. I've forgotten where that phrase, there's history about where that phrase was started, the first person who used that phrase, right of publicity. And the court, the Supreme Court in the state of Georgia actually said that the right of publicity rewards and encourages effort and creativity. So it's to put money, to put value on your image is what we now have as right of publicity. So for me, I don't think there's so much difference between privacy right and publicity right. But for the purposes, functionalities of our right, the effectiveness of our right, now that most of the courts are even cutting down privacy rights, the recent case in the United States Supreme Court, the abortion issue, it was anchored on right of privacy, and the Supreme Court now is now cutting it down, that it's not everything that is right of privacy. So I think maybe now we might start seeing right of publicity standing on its feet, on its own. Now, it jives, I would say comfortably now, reading and going through the civil code combined, Ethiopian civil code 27 and even 28 combined with the copyright laws, the economic rights of copyright and moral rights with section 2. I think we will be in good company and good authority to align with the rights of publicity laws in all jurisdictions, whether it's common law, whether it's civil law, because the ingredients, if you really look at it very well, copyright doesn't really protect this issue.
Yeah.
Copyright, I mean, UK, they are still using the common law passing off and all that. It's mostly in Europe and in Africa that we have now been making laws, specifically to deal with it. South Africa is even ahead of a lot of countries. Nigeria doesn't have it, doesn't have a robust, they tried to include it in the current amendment of the copyright laws, but they deleted it out of it. So they might have to make, a robust contemporary right of publicity on its own to deal with issues like this. In the meantime, we will be hanging on the common law issue. So yeah, I would say, because see, look at it if you read the issues very well, you see, the exclusion or the exemption in Article 21 is conscious. If you read it entirely, it's conscious of the fact, justified. Why you got to be justified before you use it. Okay, so how do you prove the justiciability of using, or the exemption rights they are exerting in using somebody's image, somebody's photograph? If you can't, then we have to fall back on the owner. But the problem, the loophole in this Ethiopian law is that I think the owner of the image does not really have a lot of remedy. Yeah. That is another thing I've seen.
Yeah.
The remedy actually goes to, because there's no clear remedy. There is no law here that says, unlike copyright law, that says if you do this is the penalty or this is damage. But here, there's no direct place that the law says maybe you pay a fine or you do this. It's in the air, maybe for case law to decide. So, or maybe the case law, the court would have to go into the copyright laws, if it's allowed, borrow from the copyright laws, and determine damages. So it's still weak. That's my assessment. It's still for the owner of the image. You might tell them to pull it down, or using the remedies in the digital creative spaces, writing to Google, writing to the ISPs, so, oh, that's my image, it's against the law, pull it down, that might be the end of it. What about the monetary damages? How do we assess it? What about, but those are the territories where copyright can come in under moral rights. Yeah. Because there are a lot of penalties that, even monetary, under the copyright law.
So on this point, another observation that I'm making is that in a number of African countries, the data protection regulatory framework is sort of overcrowding this personality law space, because I've seen people, even when I present on image rights, people will always ask me, what about the data protection legislation that protects these interests? Because obviously the use of people's images, whether it's their name, likeness, and all that, it all forms part of their personal data, their personal information. So surely data protection could come in. In the context of South Africa, the tricky part is always that on social media, you're dealing with private relationships. So the infringement is happening in a private law context. Whereas our data protection legislation, which is the POPI Act, governs private and public bodies. And so we still fall back on the common law in order to address the specific image rights issues under the right to identity and the right to privacy. But I do see in instances where public and private bodies are part and parcel of the violation, I do see our data protection legislation coming to the rescue of the victim. Are there any, like any of this overlap between image rights and data protection legislation, or attempts to regulate data protection under Ethiopian law? Is there that overlap taking place?
You rightly said it's been a troublesome, not just in Ethiopia. It's a data, and it's been a problem right now. And for instance, the example you just gave is even problematic. I would say that image is not data, but I get the argument that people are trying to bring image, and there's no agreement. A lot of scholars don't agree on data is data. We are talking of figures, codes, and bots and all those stuff. Those are data, and copyright law per se does not protect data, the figures. It per se, it's just probably the arrangement of it, tables and all that. But there are specific laws. A lot of countries are doing that now. I'm not aware yet, but I know in Ethiopia, they're working on it, and don't forget the history of Ethiopia. Ethiopia is just coming into the democratic system after suffering from that military, intervention. So, and they are really doing well in terms of changing their telecommunication law. Yeah, they have a lot of electronic telecommunication laws, but I've not really seen the kind of laws we are talking about now in terms of like European Union is in the forefront, even stronger than America, in terms of that data issues. Is a big thing now, like you said, because now we have NFTs, non-fungible tokens, which it's probably going to fall on, because there's a lot of blockchain issues that are in the territory of data and all that. So I think Ethiopia has to also focus on that area, making specific laws. Otherwise, we'll still be having to borrow laws or borrow common law and all that. Right now, it's not very robust. It's not. I mean, South Africa is ahead in a lot of this jurisprudence that is competing with technology. The technology is faster and law takes a while to catch up. It takes a while to catch up with technology. But Nigeria is working on a comprehensive data law. In fact, Nigeria is actually doing very well. They have, not too strong, but they have something aside now that really protects people's privacy in terms of data, because you are correct. I mean, they know where you are, you and I, because of cell phone, they can track us, they know where we are. They know, that's why they send us all those adverts they are sending, that people are selling our data, information. It's money, it's a lot of money. So but as we are at this point, I'm not aware of any robust law in Ethiopia that to be strong enough. So we're still gonna be looking at our traditional IP laws, and Ethiopia is not common law, it's civil law. So we look into laws, most of those laws in Europe, like Germany, France, who have the same legal regime, tradition, civil law tradition. Yeah.
Do you think that if Ethiopia were a common law jurisdiction, do you think there'd definitely be some advancement, especially with the interpretation of the provisions that we were discussing earlier? Do you think that?
Yeah. I don't know if you've seen the paper I wrote about Ethiopia's sovereignty. Ethiopia is a very proud country. I mean, it's the only African country, probably the only country in the world that has not been colonized. Nobody colonized them, and a lot of people don't know that history. They defeated all the powers, So these people are very proud. They are proud of their heritage. And they are very careful. In that paper, I talked about their sovereignty, protecting their sovereignty. They are very careful in just taking hook, line and sinker, anything from anywhere. Most of the things in Ethiopia are traditional, indigenous, most of their stuff. So yes, why it would have been more robust than it is because we learn. We see now we are looking for case law, even on this issue of image rights. We are looking for case law, common law based on precedent. So it helps you to see how the other guys are dealt with a legal problem. You borrow and implement it suiting your own circumstance. So yeah, it would have been, most of they don't, English is not, English is not Ethiopia's official language. They have Amharic. So you can see how traditional and indigenous they are, and proud people. So I am sure as the influence of international trade and their abilities now, which they are doing now, to reach out to other parts of the world, they just open up the space of their telecommunications. Now people are bidding to expand their teledensity, the bandwidth. So I mean, it's a work in progress, and I'm sure they are doing well if they can overcome their little differences of the wars and the normal African problems. Yeah.
Wow. This was a very insightful discussion. I mean, I am not really all that familiar with civil law, given that I've been trained in a country that is a common law jurisdiction. And so a lot of the times, as you said, we rely on precedent, to develop these laws and so forth. So we do not even have any legislation specifically dedicated to image rights regulation. And so we have now this, because South Africa is a hybrid legal system, we are using this hybrid model where obviously the constitution is supreme, but we have common law and other legislation like Cyber Crimes Act in the criminal context and the Protection of Personal Information Act that all come together with the Electronic and Communications Transactions Act to create a proper image rights framework. And there are disadvantages to having that kind of fragmented approach, but I see the advantage of the many angles from which image rights could be protected through the different legal principles that are found in both common law and statutes. Yeah. And so,
go ahead.
So it's quite interesting to hear the Ethiopian approach, and I hope there's a lot of case law yet to come so that we can actually suss out what the provisions mean. Because I as you were describing, I thought to myself, there's a question of ownership that seriously needs to be answered, because even that could affect one's ability to claim in the face of an outright violation of someone's image rights. And it would be a pity to lose a claim just because the principles are not clear about who can actually enforce these rights. So it's quite an interesting discussion that we've had here today.
Yeah, thank you. Let me just respond. Sorry, let me just respond before I forget it. So I won't chop too much into your time. You know, I agree that we should have a lot of sources, you know, but my problem with having so many sources for certain laws, you know, that's why that's one part of the civil law I love, you know, they are codified, their laws are codified. So you could always go to one area and see the laws. And the problem in a developing economy or a developing society of like going to the Telecommunication Trade Act, going to the right of privacy, the problem is going to be a problem of jurisprudence. It's going to be who are the people, who are the judges, how. I'm not saying in Africa we have most of the brightest scholars, jurists, but these are all what I call specialty areas.
Yes.
You know, so this is not just the lower level law. This is so there has to be a little bit of expertise, knowledge. Now, so when you are defining, I'll give you an example, a small example. Recently, I mean, we've written about it, so it's not like I'm throwing anybody under the bus. It's even in one of my last article, on my last paper I published early this year. A judge in Nigeria made a very common error that a copyright scholar 101 should not make. I mean, deciding at that level, I'm sure they're going to appeal, the parties are going to appeal, that because the plaintiff did not register their literary work, so copyright does not attach. So see, you would have expected that a judge of a high court should know that, okay? That copyright does not attach by registration, it's attached by creation.
Yeah.
You don't need it. From the Berne law, Berne Convention, down to, yes, I know America has a unique sense in terms of standing and procedural damages that you have to register your copyright, but America is sophisticated. They practice IP for a long time.
Yes.
It's about litigation. The need for you to register your copyright is not to have right of ownership. It's just to have standing and to help when they want to calculate the damages, because we have a statutory damages and other damages. So now you have to be able to understand the basic laws. So when you are talking of issues like privacy in the digital age, it becomes a little bit complicated. Now we are talking of NFTs, that is a different beast altogether. We are still figuring out what NFTs are. We are talking of IAs now, artificial intelligence. So it's going to be so many different laws that you will be confused. And our law schools, are they equipped in their curriculum? So I'm always conscious of the fact that we should try and bring these laws in the books in one place.
Yeah.
Take them from the other places that are not necessary. You do that, delete, amend the other laws, take them out there and bring them here. It makes it easy. See, like this, I'm sure what we are saying now, so people are going to listen to it. They will go back and look at it. Maybe people have not really seen it the way we are seeing it now. Probably when we publish an article, if you write about it, someone will go into it. Because I took time when you told me I'm going to appear here to really go back and look at the laws very well. You know, I used to read it, but so I saw those things. I said, oh, look, you know, is the way it's defined here in the civil code, which came before the copyright law, is different. You don't own the image. The image in the photograph, it does not belong to you. So if it does not belong to you, what are your remedies?
True.
I'm talking of tangible remedies. The guy who owns the photograph is the one you are going to deal with. So maybe for practical purposes, both of you, the guy who created the photograph will sue and join you, you know, so that you can have it. So there's a lot of ways we can discuss this issue.
It's interesting you mentioned that you could join the person who took the photograph. Now it takes me to think about what happened to Jennifer Lopez a couple of years ago, where she had a photographer take a couple of pictures of her, but then she kept one of the photos and posted it on her Instagram. The photographer sued her, but I'm not sure what the outcome was because I didn't follow the judgment, and I'm not sure whether it actually went all the way through to court or if it was settled out of court. But I found it quite interesting that such a dispute would be quite difficult to resolve in the Ethiopian context because of the ambiguity and confusion in the provisions that speak of ownership. Because now, which rights are stronger, that of the person appearing in the photograph or that of the photographer?
Well, now that you are saying it, now that we are saying it, maybe somebody should go and test it. Maybe they'll call us as expert witness or something. I mean, it's always good. It's always good to test the law to develop the law, because you know we might be helping create something new here.
Yes.
I mean, but from the face of it, I just read it. I took time to read so that people who are going to listen to it after watch this program after now, they will see the complexity. I'm not going to say confusion, the complexity, the law as it is, with another law, who tends to be the mother of creative laws, you know. And if you want to make money from damages, I would, as a lawyer, I would say, let's go through the copyright law, because I could use what is here and combine it with here, because moral rights, economic rights, and all that is stronger here, but it's not explained well here.
Yeah.
You know, and there is no law. I checked. There is no law or any other law out there.
I'm always uncomfortable with legal uncertainty, though. That idea that it's about which laws you rely on. So now your case relies on that to get, you know, to succeed. So if you've got a good lawyer who can think about these issues properly and choose carefully depending on the facts of your case, then you may win the case, but you could lose the case because it's like a pick and choose situation. Which one are you gonna bet on?
That's why they pay the good lawyers big money. So the lawyers will always try to figure out the best approach, and that's where it comes in. But there's still going to be a problem until this is tested, and maybe from the cases the laws are changed. Now, as a matter of fact, I'm gonna also do more work on it after this talk. I'm gonna do more work, maybe short paper or in the media. Let's see the reaction.
Yeah, let's continue the conversation. Yes.
Not a full-blown article, but just media short and see the reaction from Ethiopian scholars, mostly the indigenous Ethiopian scholars, and see their response and how to go about it. Yeah.
I agree. Wow, Dr. Andrews, this was a very insightful conversation. In closing, I just wanted to find out, how can our audience reach you on either via email, if you're willing to share your email, or on social media platforms? What is your handle? How can you be reached?
Oh yeah, my email, yeah, the email you have, that's the general email for, that's the general email for whatever, you know, because that's always screened. Yeah, I think to you, I don't, let me see, I wrote it down somewhere. So I'm on LinkedIn, you know, or should I type it to you, or you want me to call it out?
No, you can share with the audience. You're on LinkedIn, and are
Okay.
you on Twitter or something?
No, I'm on everything. I'm a digital lawyer, so I'm actually, the best way is at SamiI. So at SamiI, you will get me on Twitter at SamiI. Then I'm on LinkedIn, the same SamiI. Facebook, the same SamiI. You know, Instagram at the Samia, at Samia, the same Samia, you know. Then TikTok, the real Samia, at the real Samia. So Samia is just, and you know, my name is unique. I was told to get a trademark. I said, I don't need to get a trademark because there's nobody in the world so far. That's it. I'm gonna have a hold by this distinctiveness and use. Yes. So I don't need to waste money with trademark.
Yes. Yeah. Well, there you have it. Thank you so much, Dr. Andrews. I enjoyed this conversation, and I look forward to reading your paper that you're going to draft now after our conversation. And in future, I'll also approach you again to do a much more comprehensive paper on image rights, a comparative analysis on image rights. I thank you so much, and I'm sure the audience enjoyed this. Thank you.
Thank you, Nomalanga. I really had fun. I tell you, it's a good Tuesday, you know. Although it looks like, thank you so much. I appreciate it.
Remember to control your image rights.